Hi everyone, and welcome to our Google Hangout, Estate Planning in the Digital Age. I'm Kristin Arnold, Social Content Manager for Ally Bank.
And I'm Janet Reusch, Social Media Community Manager for Bankrate.com. This week is National Estate Planning Awareness Week, and to support this element of financial wellness, we wanted to highlight an emerging focus in estate planning.
That's right, the estate planning process begins with an accounting of your assets and how you want them managed and distributed. And in an ever-changing digital world, or an increasing digital world, it's not just your tangible assets that hold value, but it's also your online assets.
So joining us today to share her knowledge on digital estate planning is Suzanne Walsh. She's principal at Cummings in Lockwood in West Hartford, Connecticut, and drafting committee chair of the Fiduciary Access to Digital Assets Act.
Welcome, Suzanne.
Thank you. Thank you for having me, Kristin and Janet.
Definitely.
Our second panelist, Naomi Cahn, professor of law at George Washington University, may be joining us a little bit later. So we'll actually go into further detail about the Uniform Fiduciary Access to Digital Assets Act and how it may improve the right for you to manage your own digital assets and also manage the digital assets of a loved one who's passed on. But before we begin, I want to take a moment to let everyone know that our discussion today is not meant to provide any legal or estate planning advice. Rather, you should speak to a qualified estate planning attorney with any specific questions that you have.
So let's jump into our first question, Suzanne. What are digital assets? There doesn't seem to be a cohesive definition out there, so how would you define it?
So that's a great question. When we started drafting the Fiduciary Access to Digital Assets Act, we started off with like a laundry list definition. So I'll start there and then I'll tell you where we ended up. The laundry list was things like email accounts, any online account, digital music, digital files. It can be a cloud-based storage account. It could be a domain name, a website, and you can sort of go on and on. What we ended up using is a definition that's simply an electronic record. Digital assets are basically electronic records. So we think of that as anything you access with a computer or store electronically on the computer.
Interesting. And those digital assets hold both financial and sentimental value, correct?
Absolutely. Absolutely. And depending on the client, one is more important than the other. For many clients, it's the assets with sentimental value. We've heard from a lot of people that it's impossible to plan a funeral without access to the decedent's social media accounts, to their address book, to their photographs, or perhaps even their music files.
Wow, interesting. Everything that we do now in our lives is not on paper. Well, a lot of things don't have a paper trail anymore. Everything's digitized. So
we had an observer who attended our first drafting committee meeting, and he said he was 32 years old, and his business was web-based, and he said, everything I do on my laptop, which was sitting in front of him. He said, I don't have anything other than this and the assets in my apartment.
So how can people account for their digital assets in their estate plan? What's the first step?
So there's two big ways. The first is to make sure when you're disposing of your assets, you're including specifically your digital assets. So the most common example we used is, what if I'm an author and I'm storing my manuscripts, or what used to be manuscripts, in a computer or online? I need to account for the disposition of those files. And the other thing is to make sure that your fiduciary is competent to deal with digital assets. You need to think about that now. Is this someone who knows where to look for my digital assets? And have I told them what they are and where to look? So you need to provide that information to your fiduciary, or they perhaps will not be able to discover and collect those assets.
Do you have a best practice that you recommend for letting your fiduciary know where to find that information?
I think it's going to vary depending on the client. We always suggest not memorializing it necessarily in writing only. So I'm talking to clients now about password services, mostly for the non-monetary value assets, particularly for the sentimental ones. But there has to be some sort of list separate and apart from the traditional, we can always look at your tax return and find out where your assets are. That doesn't necessarily cover anything now. Family members know, so perhaps they can designate a family member to contact.
Okay.
I actually had someone in for estate planning last week, and she said, I'm embarrassed to tell you this, but I have this paper, and it's all wrinkled, and it's where I write all my passwords, and I actually thought of laminating it. So everyone is thinking about this now, I think.
Right.
And Suzanne, if people aren't taking these steps, what are some difficulties that arise if you don't plan for access to your own digital assets?
Well, here are some of the stories we have heard. One of them was a sole proprietor who was managing his business using business credit cards, and he was receiving the bills in his email, and he had a stroke and thankfully recovered. But during the few months that he was unable to speak, his family couldn't access the bills or paid the bills, and the credit card company refused to waive several $1,000s in interest charges. We heard one person talk about the inability to render invoices. Another incapacitated person who had a stroke, and he had, I think it was an organ tuning business, and he had all this work that he had to invoice quickly or the value of the receivables was going to be lost, and the guardian needed that money to pay his hospital bills. So it's quick access, the same as any traditional estate administration. We always needed quick access, but I think now it's more important.
So, I wanted to ask a question too, and that's the financial side of it too. But when we're talking about, you know, things like Facebook, some of our social media accounts, those are the sentimental values that, you know, families and friends place on these digital assets like pictures. So what are some of the things that people don't plan for that way? I mean, most of the sites that you upload pictures to, Instagram, they have their kind of their own laws protecting those assets, correct?
Right. Most of those terms of service agreements that we all click through when we open up the accounts do bar third-party access.
Nobody reads, right?
Exactly. Did you folks hear about the case that was in the press a couple weeks ago? There was a company trying to highlight the dangers of public Wi-Fi. So you know how you access the public Wi-Fi and you have to agree, here's the terms? They inserted a provision that said you are giving the company your firstborn child for all eternity, and 6 people signed up for the service.
Wow.
That's my latest and favorite example of how no one reads terms of service agreements.
Right.
So you're right, they prohibit third-party access. So one thing you might be able to do is, if you have the luxury of planning ahead and you know your family might want to access photos, you can upload them to a commercial service. Snapfish leaps into my mind, and you can give someone else access to that album or whatever. The cloud-based services, you would need to provide some sort of family or third-party access to those. Absolutely. Or even just the passcode to your phone if your photos are there.
So kind of touching on these terms of service agreements, what are the current legal issues surrounding digital assets in estate planning?
The biggest problem is, as we were just discussing, most of the terms of service agreements flat out prohibit third-party access. Many of them prohibit transfer of the account as well. Our Act doesn't give the fiduciary the right to transfer where the account holder doesn't have it, but it does provide that the fiduciary be given the access. So it would avoid those provisions that flat out say nobody gets into this account but you. Our Act creates an exception and says, no, the fiduciary gets to get in there and do his or her job and move on. So that's a big problem, the terms of service agreements, and the other big problem is the federal privacy law, which in many cases, for many accounts, will prohibit the custodian from releasing the information upon the fiduciary's request. So our Act says, no, if it's a fiduciary who meets the criteria of the Act, where there hasn't been, where the account holder hasn't barred access or a court has given access, our Act would require the custodian to give the fiduciary access to the account. And the problem is existing probate laws, with very few exceptions, don't do that. They don't cover digital assets at all. They don't think about the federal privacy laws, and so the reaction of the providers has been, you can't have it. You don't get in.
So with all these roadblocks, is there anything else, or is there an alternative that people can put into place to actually, you know, estate plan or be the fiduciary for digital assets?
I think the most practical one that will work on a variety of accounts, perhaps more of them with just the sentiment of value, is some sort of password storage system. I'm no expert in that software. I use one myself, and from what little I've seen, the idea behind those is it stores the passwords for you, but it also allows you to designate someone who can have access to the account if something happens to you. Or you can just simply give your spouse or your designated fiduciary the master password.
What about putting your digital assets into a trust?
Interesting question. I know there are some planners who sort of advertise that, but that violates the terms of service agreements. So that, under existing laws, isn't going to work. It's going to flat out violate those terms of service agreements in the same manner as just regular fiduciary access. What our act did is we don't address that issue necessarily. What we do is we give trustees access under most circumstances, but we leave it up to the trustees and the custodian of the account to figure out how exactly you manage the transfer. Our theory is that if you expressly say in your trust, my trustee should have access to this asset or account, you can sort of take that to the custodian, like taking it to the bank, and you can say, look, this says I can access this. And we're thinking that will work and allow the trustee to manage the asset after it's in the trust.
Okay. Now, there are just a handful of states that actually have some laws surrounding fiduciary access to digital assets in estate planning. What are those states, and what are some of the laws that they have in place?
Good. So my state, Connecticut, was the first one, and our statute is fairly typical of the older ones. It just says that an executor who's administering a decedent's estate can access email. I believe it was enacted in response to the Justin Ellsworth case where the father of a deceased Marine wanted access to his Yahoo email account. And that was not a Connecticut case, but I think that was our response. So the other states that have laws are Idaho, Oklahoma, Indiana, Louisiana, Rhode Island, Nevada, and Virginia. Virginia's is parental access to a minor's account. None of those cover all of the different types of fiduciaries. There are personal representatives who are administering estates, agents acting under powers of attorney, conservators or guardians, the terms vary by state, of incapables, and then trustees. The only law in the books that governs all of those is Delaware, and that was based on the Uniform Fiduciary Access to Digital Assets Act and was just recently enacted, maybe in August, very recent.
I want to go into that law a little bit more, since Delaware was the first state to adopt it. Tell us what that means for the residents of Delaware when it comes to digital assets in their estate plan.
It means that their fiduciaries have a law that supports their access. So if they attempt to access an email account that they need to administer the estate or any other type of online account or access, and the custodian says no, the law supports their access. The law gives them the ability to go into court and have an order compelling the access. But it's only going to cover the fiduciaries operating in Delaware. It's not going to help you in Connecticut. I'm in Connecticut. It's not going to help me very much. It will only help trustees of Delaware trusts, folks administering the estates of a Delaware decedent, acting for a Delaware incapable, or agents under a Delaware resident's power of attorney.
Okay.
And one question I've gotten a lot, which I'll just answer, is, well, what if the company's incorporated in Delaware? Because we know Delaware.
And that was my very next question.
That doesn't help. It's where the fiduciary is acting. That law is going to govern their actions.
Okay.
So as we see all these state laws kind of emerge organically and with different rules and regulations, what is the goal of the Uniform Fiduciary Access to Digital Assets Act? Will that sort of bring some uniformity across the states, or what do you see happening with that?
Well, the goal is, of course, uniformity, so that many people have assets or estates being administered in multiple states. Many people move while they're incapable. So we don't want the access and the administration of their assets affected by that transition. So the idea is once there is widespread enactment, and that takes a few years because legislatures are slow. Not every state's legislature is actually in session every year. So it'll take a few years before we get this critical mass of states. Once that happens, our hope is that the custodians and the industry will start to accept that this is the way they're going to have to operate. They will start to address this within their own terms of service agreements. The Act does recognize that they can do that, that it's just fine if, well, Google has an inactive account manager right now, where if you have a Gmail account, you can specify who has access to it within the Gmail account. You don't have to have a separate document. And our Act validates that as long as it's a knowing opt-in, it's a knowing decision by the account holder. It's not buried in that terms of service agreement. So uniformity helps the fiduciaries, but it also helps the industry. If they have the same set of rules that apply, and I would imagine it would help banks as well. It's always helpful for banks that operate in multiple states to have the same set of rules applying, and so on. You know.
As this emerges, because this is an emerging topic as more people collect digital assets online, is this going to be something that people push for as they realize that they don't have access to what they need? You know, not only, you know, how you can decide where your assets can be managed after you're gone, but also how you can manage other people's assets if you are named a fiduciary.
So you asked, is this something people are going to push for? I think on a sort of constituent or legislative level, yes. We've actually seen in Minnesota, there was a woman who was denied access to a deceased family member's Facebook account who initiated an online petition to petition her legislators to move this along. Ricky Reusch in Virginia is a dairy farmer who famously advocated for the enactment of its social media law. So a lot of family members who've been denied access and were appropriately angry about that have been advocating for enactment in their state. There's another reason why we've seen people advocate for some legislation, and that is that our Act, it empowers the account holder. So if the account holder wants access, it empowers that, but it also allows the account holder to deny access. So let's say I don't want anybody in the world, including my fiduciary, to access something, right? I may have any reason at all. Our Act says you can do that. We call it effectuating intent in the estate planning business. So if that's your intent, we talked in our drafting committee about folks who might make their living in an industry they don't want their family to know about. And there might be digital assets, let's say DVDs or online files, that they want destroyed. So they might want their fiduciary to access and destroy. They might not want anyone to access. They may have a secret account somewhere. All of that is allowable and encouraged under our Act. There's no, it doesn't mandate fiduciary access. It just says fiduciaries should have access unless there's been evidence to the contrary. And that can be something that's received by the court. It can be I put it in my will. It can be a provision I put in a power of attorney.
Interesting. Yeah. Well, I'm sure that we'll be hearing a lot more about this in the coming years. So I want to thank you, Suzanne, for being our panelist today and basically helping our audience better understand and plan their digital assets and understand their rights in digital asset estate planning. Of course, as I want to mention again, it's always best to consult a licensed estate planning attorney in your state to create a digital estate plan that meets your needs. For more information on digital assets and estate planning, you can visit the Ally Bank Straight Talk blog. I want to thank everybody for watching and joining us today. So until next time, have a great day.